wheels move quicker, and get people to where they need to be, then, if it's a matter of somebody needs a bed, then I'm going to do my best to get them their bed.
Squeaky wheel, Your Honor.
Yeah. All right, we're back on the record in Jeremiah Melvin Simmons. And I'm so sorry, if you all could re-announce, please.
Jason Garahan for the state, Your Honor.
Zero for Jeremiah Simmons.
Jeremiah Simmons.
All right.
Jeremiah Simmons.
Counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Simmons, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I just want to make sure that if it's listed as a repeater, and I just still have the indictment in front of me.
Okay, let me see.
Okay, I've been informed.
No.
It was not. So we're proceeding on the indictment as it was indicted.
All right, thank you.
Yes.
Mr. Simmons, did you review the court admonishments and defendant's waivers with your attorney? Did you understand it?
Yes, ma'am.
You're charged with aggravated robbery. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Simmons, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to a jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes,
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, there's a no contact order. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest.
State, any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attachments.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and review the same.
Bless
Thank you. All right, after reviewing state's exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Respectfully, Your Honor, asking to follow the plea agreement. That responsibility he wants to fund.
All right, so let's talk about the contact. Yes, with Samantha Rendon.
Samantha, that is his wife, Your Honor.
Well, this is sort of like a Bunny and Clyde situation, though.
Your Honor, I understand, but they do share a child together. And so again, it's one of those things that once he is released on parole, it does hope to be able to be around her and to parent with her.
All right, he'll have to take that up with his parole. The court is finding him guilty. The court will enter an affirmative finding of deadly weapon, 8 years in the prison, credit for any time served. There's a $2,000 fine. There's to be no contact with Samantha Rendon and Destiny Macias. Is there anything else?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes,
Because this plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. This wasn't a good thing to do, right? And then you have Samantha, who is the mother of your child, participating in this. That's not what a good mother does.
she,
So-
I'm sorry,
Go ahead.
she didn't participate, I was just only did it on my own.
Oh, yeah, but here's the thing. The only reason why you knew that person had $1,000 is because Samantha told you. Otherwise, why is, and you don't have to address this, we're not on the record. Why would Samantha go to a place talking about she's going to go pick up somebody after her friend of 8 years is trying to buy a car, probably struggled to get that money together, goes to the ATM machine to get $1,000, and then she really needed another $1,000, but the ATM wasn't working. So she calls customer service and say, I need another $1,000. And then mysteriously, the mother of your child has to go off in some area for some unknown reason to meet somebody, and that person comes up, which was you, pulls out a gun and takes the $1,000 in that person's ATM card. So Samantha Rendon, what you should be doing is making sure that your mother or there's some adult who is following the law, who's raising your child. Because Samantha isn't, and who knows, Samantha may not even be waiting for you when you get out. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
Thank you. All right. You want to bring Mr. Bernal up? Hello. Yes, where are we?
Okay, Judge, I went over the complete packet that we have reviewed. This will be the third time. He did take some time to review one of the documents, which was the officer affidavit. He vehemently denied and contested that those were the police reports. He wants the actual handwritten reports taken at the
All
scene.
right. Well,
The state isn't able, and I understand, to be able to watch the videos. I'm not sure how to maneuver that issue, but at this point, I don't believe that we're able to get him what he wants today. He also mentioned that he wants a reset to have time, and I agree to review everything thoroughly. But at the same time, Judge, he is consistent on the fact that he wants, in his mind, competent counsel. And I agree. I think that, not that I'm not competent, but that we are not a good fit. He doesn't trust my counsel, my advice, my navigation, my advocacy, and all of those things. And for those reasons, I believe for him, he feels that retaining counsel is the best move for him.
Oh, sure, he can get an attorney. Ms. Ferguson, can I have a reset on this case in 10 days for a jury trial, please? Sure.
That's another day I have a statement. I don't have a mask.
Okay.
So then, not afforded the chance to be able to see.
So let me ask you this. Have you ever told your counsel that you needed glasses?
The last time.
Oh, just right now. So here's the thing. She has been going over that paperwork with you, and I've seen her go over that paperwork with you on a numerous occasions. So this is what I'm going to do. This is being recalled back for a jury trial in 10 days. Whoever you're going to hire, you need to hire them. What I can tell you is legally, if you're hiring an attorney, I don't even have to give you 10 days, but I'm going to give you that. Ms. Ferguson, 10 days, jury trial. All right, July 17th, you'll be set for jury trial. They'll bring you over dressed for trial.
Okay,
All right, thank you.
no, thank you.
And if you want him brought over for some reason to view a video that will help you out, just let us know.
Thank you, Judge.
You're welcome.
All right, here's your closing commentary in the style of Law Talk with Mike. All right, let's talk about that. This hearing with Jeremiah Simmons really underscored the seriousness of aggravated robbery charges and how carefully the court walks a defendant through every step of the plea process. Judge Boyd started by confirming that both sides had all discovery and that Mr. Simmons had reviewed everything with his attorney. You could tell she wanted no ambiguity. She went line by line through the indictment, the waivers, and the plea. Admonishments, making sure he understood the full consequences of pleading no contest to a first-degree felony that carried up to life in prison. The agreed sentence was 8 years and a $2,000 fine, with an affirmative finding that a deadly weapon had been used. One thing that stood out was Judge Boyd's discussion about contact restrictions. The defense asked if Mr. Simmons could be allowed contact with Samantha, who is not only his wife, but also the mother of his child. The judge made it plain this was no ordinary relationship. She described it as something like a Bonnie and Clyde situation, pointing out that Samantha was the person who told him about the victim's cash, and that this was no coincidence. Even though the defense emphasized the need for co-parenting after prison, Judge Boyd said those decisions would ultimately be up to parole, not the court. After formally entering the conviction, she turned to Mr. Simmons and delivered a firm reality check. She questioned why Samantha would involve herself in luring someone to an ATM, why he thought this was a good idea, and whether he grasped how damaging it was for everyone involved, including their child. She didn't say it to humiliate him, but to underline that this wasn't a momentary lapse in judgment. It was a planned, violent act with long-term consequences. The hearing wrapped up with all the required paperwork, a waiver of appeal, a reminder he could no longer own firearms, and a final note that the court had no illusions about the facts of the case. If there was any lightness in the proceeding, it came from the contrast with the next defendant, who spent the better part of the day insisting he needed handwritten police notes and that his attorney wasn't a good fit. Judge Boyd patiently explained she'd already seen the defense counsel go over the materials multiple times. She granted a reset for him to hire new counsel, but reminded him that trial was coming in just 10 days. All in all, it was a sobering hearing that showed how the court balances careful procedure, respect for rights, and the blunt reality that a serious crime leaves scars no plea agreement can erase. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one, asterisk.